We take pictures of the courtroom? It's gorgeous room.
Oh, thank you. It's definitely one of the nicer courthouses. Definitely the nicest.
We're not in the Vatican, I guess we can have flashes, flash photography.
Just make sure you turn it off before
Charlotte here for the newsletter.
judges come in.
Oh,
Just imagine how much it would cost to build those ceilings today.
it's in my kitchen.
I mean, that's all hand carved.
Yeah.
You know how many hours it would take to do that?
see any. Please be seated. Okay, good afternoon, everyone. Before we begin, my colleagues and I would like to acknowledge the presence of Judge Norman St. George, the Deputy Chief Administrative Judge for the courts outside New York City. Thank you for being here, Judge St. George. Judge Rivera will be appearing for oral argument remotely, and the first case on the calendar is Appeal Number 73, Plymouth Venture Partners versus GTR Source and Capital Merchant Services. Counsel?
Good afternoon. May it please the court, Shane Heskin on behalf of plaintiffs' appellants. I'd respectfully request 3 minutes of rebuttal.
3 minutes, sir?
3 minutes.
You may have 3 minutes.
Thank you. There are 30,000 reasons why this court must answer the certified questions yes. That is the number of judgments that the MCAs have amassed in this court system. Unfortunately, that number is only growing through default judgments even today, even after the legislature stopped the confessions of judgment. What happened here is a rogue New York City marshal reached across state lines in Michigan, froze a bank account, causing an avalanche of adverse effects, missing payroll, defaulting on other lenders, and getting put into a receivership. It cannot
So, I'm sorry,
be-
counsel here, sorry.
Sure.
At that time, when the bank account was frozen, as I recollect, the debtor went into the court and tried to get the judgment reversed, right? Why isn't the proper thing to do then, at the same time, to seek to get this execution undone? Why do we wait all these years, and now we have a federal action, and now do we have damages? Do we have a marshal involved? When it all could have been taken care of then?
Well, there are a couple of reasons. One is there didn't need to be a void to vacate the judgment or the levy at that time. First of all, what they did, the first efforts were to try and vacate it on a couple procedural grounds, which was they didn't file it in the county. The second was under BCL 1314. where we're trying to get the judgment vacated altogether. It's very expensive and time-consuming to have to file a plenary action, which the court would have required. Is you have to file a plenary action, you have to litigate it on the merits and overturn on the usury. It's a very fact-intensive process. That's expensive. You're talking about...
But why couldn't they come in on an Article 52 and say this is an improper attachment? They had notice, they had the time. Come in and say it's an improper attachment. Why not?
They could have, but didn't need to. So
Why? Because we'd rather, as a policy matter, have this?
Well, as a matter of public policy, you shouldn't, a debtor in California who had their bank accounts attached and seized by a New York City marshal shouldn't have to come to New York to...
But they're subject to jurisdiction, the judgment is in New York, so why shouldn't they have to come to New York?
Because the process is void from inception. It's not necessary.
But that seems like a non sequitur. So they have a valid judgment in New York. They're subject to jurisdiction in New York court. They get notice one of their bank accounts is attached. They come to New York and they say you shouldn't have attached this. I mean, they could bring a federal action years later, you know, in a district court, but that seems a little less convenient and efficient.
It's not what's required under the statute. And for example, look what happened in Silver Cup, okay? Silver Cup we did exactly that. And there's a big distinction there, because in Silver Cup, the marshal acted within his authority. He served it within...
Article 52 case?
Silver Cup was in Article 52, yeah.
Right.
So he served it within New York City. So there, he had the jurisdiction, he had the authority to issue it. So that's what brings it within Article 52. Now, we got that vacated, but we were then required to seek a plenary action to get damages for that. So it's not something that's economically feasible by just going in New York and getting that modified, because now we can bring a plenary action. We don't have to bring it in upstate New York. We can bring it in federal court. It's not required. So that's the distinction between void and voidable. And where the marshal acts within his jurisdiction, then yes, we have to go to Article 52 applies. We have to go to that court and get it vacated, and then we seek a plenary action.
But counsel, I mean, that's clearly not the case. The assets were levied upon. The bank released those assets to the judgment creditor. To make a distinction between void and voidable seems somewhat incongruous, given the fact that the proceeds actually made it to the judgment creditor. And I think the question here is, why wasn't there an effort to void the encumbrance?
Because there was an action brought, and common law allows you to bring an action for wrongful execution. It's a void process. We don't have, what you have to understand is that in these confessions of judgment, they authorize judgment to be entered anywhere in New York, in any county in New York.
I thought it was 2 counties.
No. So maybe today, but prior, it said it had to be
So
entered
should we have a
in...
different rule if it's a case like this and it's a judgment creditor that we find particularly offensive? We have a rule, but if it's a different judgment, we have a different rule?
No, that's not the
So
case
what
at
do the
all.
facts matter in that sense? Like, what does it matter that this was a confession of judgment or that it was this type of loan? Because if we make a rule, it's going to apply to every case.
Sure. And the key here is that Article 52 simply does not apply. It's not efficient. It's a void process. And the judgment, the victim has the right to go anywhere, any court they want to get the relief, because it's void.
Will you help me with the record a little bit? I thought, at least as to GTR, there was a motion made by you under 5240. Is that wrong?
That is wrong. That is not correct. We didn't do it under 52 in the state court. We did that in Silver Cup. In Silver Cup, we did a motion for 52. In GTR, we did 2 things. We sought to vacate it because of the county issue. They filed it in the wrong, one of 62 counties. and then BCL
I thought
13,
before the
14.
receiver became involved, there was actually a motion made in front of Supreme Court on 5240.
It was only to vacate the judgment, and then upon vacating the judgment, it was for restitution, is to turn over the funds. And that motion procedurally was denied. So then, after that was procedurally denied, we filed it in federal court on the wrongful execution claim. And that is, the difference is that if we had to vacate the judgment up in New York first, which we don't have to do because the process was void from its inception, and that's the key distinction, is that if you, once the marshal acts outside of his jurisdiction, that is void. It never happened, and he therefore didn't have authority. Once he served something in Michigan.
So that means that, so that's your response to that there was not a tort here at all. In other words, your void versus voidable argument is the basis for you rejecting GTR's argument that this is a valid money judgment, and even if the service was improper, it's irrelevant since it's a valid money judgment, and you're not entitled to any damages beyond those damages. So there really wasn't a tort at all here to begin with.
Well, there is. There's definitely a tort. There are definitely damages.
All right. It seems to me, if you have a valid money judgment, then that's the damages that you're entitled to. And for there to be a tort, you would have to show us something beyond that money judgment for damages. There'd have to be established proximate cause and show that there are some other damages beyond this money judgment, and I don't see those in the tort that's pled.
Well, there was money in the account, and now there wasn't money in the account. So they took the money in the account. And think about how this would play out in this case.
Well, let's just stay with my tort argument,
Sure.
right? What I'm interested in is the fundamental question here is there a tort? And so we got a duty, a breach of a duty, a negligent action. Let's give you all those. I think it's a fair argument. Then we say, what are the damages, and is there proximate cause establishing those damages? Well, if we apply the but-for principle in proximate cause, it's pretty hard to show that you have anything beyond a money judgment as damages. So therefore, if the money judgment is valid, you have no cognizable damages.
We do. It's simply the money that was taken out of the account. And then you'd get into
So in
the
other
issue
words, the
of
money
cost.
judgment, the execution of the money judgment is your damages.
The money they took out of the account.
But
I had
if the
$30,000
judgment is valid to begin with, it doesn't matter because it's the same dollar amount. There is no tort.
Well, then you have to apply the concepts of offset. And offsets are equitable. You cannot take your own, take money illegally and then apply it to your own judgment. We've
So
cited,
I understood your argument. Honestly, I wasn't as impressed by that argument. The one I was struggling with was whether or not there was an actual tort here. And if so, how does this play out if there aren't any ascertainable damages beyond the valid money judgment?
so let's just play out how this would work if the money was returned. If the money was returned back to,
Well, why don't you start that a little differently? If it had never been taken, start it that way.
if it had never been taken, my client would have had the money to make payroll. He wouldn't have had, he would have been able to use that money to pay senior secured creditors.
So you had
And-
a senior secured that was 5 million or so, is that right?
Exactly. And so the money would have been paid to them. And so what this rule is creating, if you allow this to go on, it's going
But
to
counsel,
encourage-
if I can interrupt you on that damages, I'm on the screen, excuse me.
Sure.
Doesn't that go to damages for a different party, not for you? Those are damages to the senior lenders?
Well, not necessarily.
That's what I'm not understanding about.
Sure.
I don't disagree with your point that it does sound like someone's jumping the queue on the creditors. I'm not going to disagree with you there. But the question is whether or not that's a tort that your client can pursue.
Sure. Well,
Damages to them.
there are a lot of consequential damages that occur from that. One is if you take the money by violating the law and I can't make payroll, I'm going to have payroll damages. There are going to be fines for that. Then also, if I had that money and I could have paid my senior secured creditors, I now have, it's like a preference payment. I now can choose how I use that money to pay off. I'd rather pay someone where that's got a senior secured lien on all of my property than pay
So
someone.
if I'm understanding your argument, I don't know that this is the way you actually litigated the case, but if I'm understanding your argument, you're saying if the law had been followed, there are particular payments that you would not have incurred, and those are the ones that you want reimbursed, not necessarily the debt itself. Am I
don't want the
understanding
debt
correctly?
Yeah, correct. I don't want the debt itself to be paid. I want if they took $300,000 out of my bank account, the $300,000 goes back into the bank account, and now we're in a receivership, and that would get distributed in order of preference. The creditors that didn't break the law would get paid first in order of their.
Yeah, but again, you're saying that the damages you actually suffered from that had to do with these fines related to payroll, or am I misunderstanding?
It's a combination. I'm saying, I'm giving you hypothetical consequences of
Yes.
what the damages could be in any particular case when you follow this rule.
Yeah, well, are those damages you asserted?
Are they, yes, we are asserting consequential damages in these cases. And so we missed payroll, we were put in a receivership, we were not able to make payments to.
So let me ask this, if they had followed the law, or if it had properly been executed, and the bank turns over that money anyway, wouldn't you have been in the same place, unable to meet payroll? I mean, that's the whole point, you don't have the money to pay your debts.
Well, if they had followed the law, we would
Yeah.
have had notice of it. They would have
Yeah.
had to come to Michigan and properly, and we could have sought injunctive relief and would have been on notice, rather than just having a marshal seize
Yeah,
their.
but notice that you owe the money, you haven't paid, and you gotta turn it over, and they're taking it from your bank account? Again, I'm not really, it'll be the last question I ask along this line. I'm a little bit confused as to how, at the end, you're put in a worse position. I was looking for that part of the damages.
Well, at the end, if this did, but for the unlawful activity, my client would have had the money, would have been able to make payroll, and it would have been able to pay its senior secured creditors. If they had followed the law, all those things would have happened. But because they did not follow the law, they woke up one morning and found their bank account frozen, they missed their payroll, they were defaulted on their senior secured creditors, and there were other consequences.
Counsel, does the bank bear any responsibility in this tort? As you say, it was a judgment void ab initio. That should have been as obvious to the bank as it was to anyone else in this transaction. What's their responsibility for turning the funds over?
There are banks that will not honor these, and there are banks that just don't want to get involved. There's no liability on the banks. They have provisions in the contracts that say if we're served with a subpoena or a levy, we have the right to honor it, whether it's valid or invalid. So they don't want to expend the resources and attorney time to actually have to try and figure that out or litigate that. So they can turn the money over, and that's typically in anyone's bank account.
Thank
So-
you, counsel. Counsel?
Thank you. Good afternoon. Ryan Cummings on behalf of GTR Source LLC. Please the court. Your honors have already touched upon the primary issue in this case, which is there's a valid judgment here. It's been litigated twice, and it's a valid judgment. So we have a valid judgment. Where we depart from the appellants here is what happens if you go and try to enforce a valid judgment as opposed to an invalid judgment, and you happen to make a mistake under Article 52? What are the consequences?
It may be a little different from that.
Okay.
Because there is the Uniform Enforcement of Foreign Judgment Act, right? And that's been adopted by almost every state, including Michigan and New York. And at least my reading of it is what you should have done once you had the valid, and I assume the judgment is valid. The Second Circuit's asked us to assume it's valid, so you don't have to argue that. If you have a valid judgment here, you have to walk it over to a Michigan court, register it there, and then levy on it there, especially when you're dealing with a third-party garnishee, a bank that has no presence here. So the question really is the last one, I think, that we were dealing with, which is, suppose that's what you had to do. And suppose, and you don't have to concede this, just suppose for the purpose of my argument that, or my hypothetical, that the marshal had no jurisdiction to attach this property in that way. You have to go through the Uniform Act and register in the Michigan court, and you didn't do that. The question, though, is what would have been different, right, had you done that? And the thing that I think we may be missing a little bit is we're being asked for a rule from the Second Circuit. And it's a rule that has to apply whether we're talking about a $150,000 judgment or a $5 million judgment. And a secured creditor in a first position who maybe should have notice of this, and procedures that are available such as bankruptcy and restructuring. We don't have to, this company, for a variety of reasons, looks like it was not going anywhere, right? But we have to consider the situation where it might be a company where you could negotiate with the first lien holder, part of the lender in the first security position, who might want a going business and might be able to work something out. So the question is, can we be sure on the first question, I'm not at the second question, the first question from the Second Circuit, that in all cases, the fact that all you're doing is executing a valid judgment through an improper means, and assume it's improper, you can tell me why it's not if you want, is that always going to be a case where you can't bring a tort action? That's the question.
And the answer is no, you should not be able to bring a tort action in that circumstance, that hypothetical that you just laid it. Ever. Because actually, Article 52 provides a mechanism for an expedited resolution of who's entitled to...
Well, that's the second question. So suppose Article 52 didn't exist, you'd have a tort action.
You might have a tort action if the improper execution was done maliciously, intentionally, something like that, where it's a simple mistake. A simple mistake. The courts in New York have said, look, well, we're not endorsing this, but you're not liable in tort. And in this particular circumstance where you have a marshal, it is not as if there is not oversight.
Well, negligence is ordinarily thought of as encompassing simple mistakes. Right, I mean, trespass to chattels works whether you're negligent or you're intentional or venal.
Actually, trespass to chattels actually does have a bit of an intent component. I just happened to finish a trial on that very issue. And it's an intentional interference with somebody else's superior possessory
You have to know
interest.
that it's their property, yes.
Yes. So those circumstances are slightly different than what we're talking about here, which is technical noncompliance with an enforcement statute. And there is an avenue. Article 52 does exist. There is an avenue for a judgment, somebody who believes they have a superior interest in that property, to come to court expeditiously within 7 days and get a determination as to who's got priority over those dollars or that property. So we do have a mechanism here. And counsel has touched upon, is it void versus voidable? And the question was asked, well, what does Comerica Bank do in this circumstance? Because Comerica is actually the one who receives the execution and is in a position to say, wait a second, we're not subject to personal jurisdiction for some reason in New York, or this isn't properly issued to us. That was a right that Comerica had.
Well, but wouldn't the damages be limited to the value of the property that was the subject of the money judgment only? And in that circumstance, you wouldn't have a valid tort. But there can be circumstances where you may have a valid tort if there were different damages.
There may be a hypothetical situation.
I mean, one thing I've learned in my grind through the legal system is the variety of damages is pretty much limitless, right? I think we'd all acknowledge that. So that being the case, they may not be in this circumstance because your damages here may be limited to a valid money judgment. But any rule that we make may need to be limited to the value of the property that was a subject of the valid money judgment only. Because anything beyond that would create a rule that would restrict tort rights that they may or may not have. And it may be that fraud, you may be into a fraud territory, you may be in ordinary negligence, but it's irrelevant for us to even reach that if we limit it to the damages that are subject to a valid judgment.
I agree with you, Your Honor. That rule seems to be narrowly tailored to the circumstances that are before the court in this
So
particular
would you be advocating a limitation like that in any response that we gave to the Second Circuit?
I think that's the issue before this court, and that would make sense to limit the response in that circumstance to this issue that has been litigated before both the Second Circuit and here.
Thank you.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Christopher Murray, Steinadler, Dabba, and Zelkowitz for the respondent, Capital Merchant Services. Your Honors, there's kind of a key factor here. Counsel has argued repeatedly that the way this case is distinguishable from Silver Cup is whether or not the service actually took place in the jurisdiction where the officer it's their county, their locale. In Capital Merchant Services case, the service took place in Rockland County by the Rockland County Sheriff's Office. He's arguing that the Comerica Bank was simply served incorrectly, but it raised no objections. That's relevant for a lot of reasons. One is that the objection would belong to Comerica Bank, and Comerica Bank has never raised that objection. It has never objected to jurisdiction or service. And in that regard, this is a lot like Kohler versus Bank of Bermuda, where if you have jurisdiction over the garnishee, because the garnishee is not objecting, and you have jurisdiction over the judgment debtor, because you have a judgment against them, there's really no issue. It doesn't matter where the property is, because you have jurisdiction over whoever it is that you need. It is based upon an in personam jurisdiction, not based upon in rem. It doesn't matter where the accounts allegedly are. So that's a key factor. Additionally, the duty that they allege was breached is not a duty that is owed to the judgment debtor. It is a duty that belongs to the bank. We didn't breach any duty to the judgment debtor. The judgment debtor is entitled to no protection based upon whether or not the bank is properly served. They suffer no injury.
Why isn't the judgment debtor entitled to protections of Michigan's enactment of the uniform law?
Respectfully, Your Honor, it's because the judgment debtor is subject to New York jurisdiction as a judgment debtor. They consented to jurisdiction here. They are subject to our jurisdiction.
Isn't it clear, though, that if their assets are not located in the state, you have to go through the Uniform Act and you have to register in Michigan?
Absolutely not, Your Honor. That is not the law. The law in Kohler versus Bank of Bermuda and in the vast majority of cases in New York is that if you have jurisdiction over the judgment debtor, you can go ahead and get your relief from the judgment debtor here. Now, if there was real property, that is actually an exception to that rule. However, in this instance, we absolutely can go after their assets because they are subject to jurisdiction here. The judgments are enforceable. That's the key fact. The case law that counsel cites where there is a void versus voidable distinction all arise from the alleged judgment being in some way defective. There's a lack of subject matter jurisdiction from the judgment. The judgment had already been satisfied. The judgment had already been vacated. The underlying debt had already been satisfied. None of that is applicable here. The judgment was enforceable. Thus, the issuance of process, the execution, was valid. Counsel's objection is not to the issuance of process. That, I think, is settled law, that the process itself is proper. His objection truly is narrowly tailored to the execution in service. He's saying that service of process thereby renders the initial issuance of an execution improper. Respectfully, that is not the law. And we cite case law to this effect within our brief, that essentially it all hinges upon the objections that it all hinges upon this.
So, just so I'm clear, are you saying that the only issue to be decided is whether or not there is a valid judgment, and the means of enforcement, whether you domesticate a foreign judgment or where you serve it or who serves it, are beside the point?
Your Honor, I would say they're beside the point as long as the issue that is allegedly technically defective that they're arguing is a protection to the non-party garnishee. If the bank had objected in this case, they would say they have no damages because nothing would have happened. Their argument is that the bank consented to jurisdiction and therefore they have damages. That can't possibly be the basis of a bright line rule, that if the bank consents to New York jurisdiction, now they have a tort claim against us. respectfully, that's not reasonable. Now, the reason counsel is bringing this as a tort claim, he makes that clear in his reply papers. He wants it to be a tort claim because he wants to sue attorneys, collections attorneys. He wants them to be alleged joint tortfeasors. That's the reality here.
Can I just ask you, as a point of personal confusion, is this enforcement tort a negligence-based tort or an intentional tort, as far as it exists out there in the world?
Your Honor, I understand it to be, he's arguing that it's something of an intentional tort.
Okay. I'm sorry, it's not clear. We talk about duties, breach, causation, negligence, reasonable people, and I begin to think that it's negligence sometimes.
Understandable. There is one last thing I did want to say. Counsel has argued about there being a senior secured creditor. There's never been any adjudication about any senior secured creditors at all. This transfer of the claim took place in the Second Circuit after the adjudication had taken place in the trial court. To that end, the idea that there's some sort of a difference in standing that he's arguing, or that he's allowed to assert an injury to the senior secured creditor, it's not correct. And more importantly, the reason why the senior secured creditors has not brought any claim is that they're not actually senior or secured as to money in a bank account. Money in a bank account is not secured by the filing of a UCC-1. It's secured by control over the bank account. And those creditors never had control over the bank account, and that's why they haven't actually challenged it, because as far as the money is concerned, they are wholly unsecured. They are, in fact, beneath us in terms of the order of priority.
Thank you, counsel. Counsel?
Thank you, Your Honor. I'll try to be as brief as possible because I know we're all on the same side here. Andrew Shriver from Cuddy and Fader on behalf of Marshall Beagle. I do want to sort of bring us back to the beginning of the issue that was presented by the Second Circuit. The key phrase was whether or not the judgment debtor suffers cognizable damages. Cognizable. I looked it up in the dictionary yesterday. Not part of the record, but common sense. That means capable of being known, right? What is the injury? We talked about it a little bit. I heard it from the bench. There is no injury here. And to the question as to whether or not, even without Article 52, this would sound in tort, the answer is no, for a very, very, very basic reason. Under New York law and pretty much every other state that I know of, you need to prove each element of your claim in order to stay in court, right? Here, let's assume for the sake of discussion, as Your Honor had pointed out, that there was liability or possibly liability on the first prong. Without proximate cause and an actual injury to the person who's bringing the claim, you don't have a case.
Right, but we are just, I think, and correct me if you think I'm wrong, the Second Circuit is just asking us about the damages element. They're asking us to assume the rest, and they're saying, is the fact that you took the money and used it to satisfy a valid debt,
right?
Is there any circumstance where that might cause damages recoverable in tort?
Okay, and so
I understand why it might not in this,
Yeah.
and I certainly appreciate in this case, if I were the plaintiff's lawyer, I would have a tremendously difficult time proving what those damages were. My question is that always going to be the case?
I think
always going to be not cognizable?
The answer to that, Your Honor, I think is yes. It will always be the case for one reason. If it's subject to a valid judgment and the debtor is the one who's bringing the claim, the theory that was advanced by counsel was, well, it was the debtor's money. It would have been in the account. We could have made payroll with it. But as a matter of judgment enforcement policy, once there's a judgment against you, the only assets that you have that are protected are those that are protected by statute, exempt under the law. Other than that, what's sitting in your account is subject to reach by any creditor. It's whoever gets there first with a validly issued levy. So the concept that I was injured because I couldn't make payroll, that injury was not because the marshal executed a levy. We all know that, but for the procedural objection, any marshal could have done it correctly. But just to finish the point, Your Honor, yeah, go ahead,
had
please.
you gone to investigate,
You see where I was going.
Had they gone to Michigan, right, and domesticated the judgment, and then there's a 21-day notice period.
Sure.
Presumably, Invest Detroit could have put them into receivership.
It could have happened. There could have been a bunch of different types of remedies, all of which would have been the equivalent of what you could have done under Article CPLR 5240, right? But that's the absurdity of this all. The theory of their case, as alleged in the complaint, is somehow the marshal should be liable for a judgment. And as you said, this is for a $127,000 case. It could be for a $10 million case. And if we start getting into whether it was intentional or not only are we stepping on the toes of the appellate division authority pursuant to the Civil Court Act, Section 1610 and 1612.
Well, the marshal may have other defenses that are not at issue here, no?
Including quasi-immunity as a public official, which we didn't get into, but it was just raised. So I want to point that out before we start, pointing the direction of that. But the biggest problem that the debtor faces in these situations is absent any other actual damage. there is no damage and therefore no claim. I'll give you a perfect example. There is a case cited, I don't have it in my memory right now, but I was reading it last night again, and there was a case where the court had said, well, the marshal in executing a valid levy was removing things from like a washing machine, a laundromat, and in that situation, the marshal damaged property, right? And even there, the court said, well, okay, maybe there's something for damages there, right? Not anything like our situation. But then the court said, but that's why there's a statutory remedy for why there's a bond required for the marshal, because you can make an application against the bond. In other words, every direction we turn in this case, at least insofar as my client is concerned, there's a statutory remedy, and there is officially sanctioned and statutorily prescribed oversight by the Department of Investigation, which in this case was contacted, did take a measure by issuing a memorandum warning, and we know under 1610 and 1612 that both the Appellate Division and the Department of Investigations have a non-delegable discretionary power to say, we're going to suspend you, we're going to remove you, and in certain circumstances, we're going to take away your badge. And where we get into the Cruz case that this court decided on similar facts when it was certified by the Second Circuit, this court properly said, why are we going there where there's already a statutory remedy under Article 52 and there's no clear evidence of legislative intent to create a private cause of action? And in this particular circumstance, we know that that was not a legislative intent because the statute specifically allows for a procedure whereby the actual...
But there I think you're missing something, because we're being asked to assume that there is a tort action. The Second Circuit's asked us to assume that. They're not asking us to create a private right of action. So we're not in that world. We're not in the create a private right of action world.
Yeah.
We're really asking whether the CPLR has supplanted, this is the second question, supplanted a tort remedy that might otherwise exist.
And I think the answer to that clearly is yes, Your Honor.
Why?
For one basic reason. Because you're dealing with a legislative scheme. I believe that it's the policy of the court in this state, and most courts in most states, is that where the legislature has, and you've talked about this at length in Cruz, you said the most important factor as to whether or not a private right of action can coexist.
That's implying a private right. We're talking about something different. We're now, assume the answer to the first question is yes. Just
Okay.
for the second, just right, imagine that's yes. It may well be no, but imagine it's yes, right? If there is a tort action, then we're asking a different question. We're not asking about whether the legislature intended to create one. We're asking whether the legislature and the CPLR intended to eliminate the common law. And that's a very different question under our jurisprudence.
So, Your Honor, I don't believe that it did intend to eliminate the common law. And the reason I can say that with some degree of confidence is because there is recognition in the Silver Cup case, by way of example, where after the thing they're complaining about, right, if they had gone under Article 52, vacated, set aside the levy, reset the clock, so to speak, I still don't think the debtor would get the money. It just means some other creditor would get it. But that's step one.
Can I
Yeah.
ask this, because this is an important point that the judge asked. The way I understand the question that's being put to us is, was there a tort violated here, which is the same thing as saying, was there a tort at all?
Right.
Right. And in the absence of damages, how can there be a tort? That's your argument, right?
Precisely.
So we don't get to the second question then. But the question that Judge Wilson, if I understand it correctly, is that may be true in this circumstance, but it can't be true in every conceivable circumstance, right?
So it's conceivable, and this goes to the colloquy I think you're having with my colleague a bit. It is conceivable, and I suppose this is why I go back to the case where, for example, the marshal damages the washer, right? In that situation, that was sloppy, that was negligent, there was property damage, it was not within the scope of the marshal's
I
duties to
understand
do
that there may be statutory remedies that supplant the common law remedies.
Right.
But there still may be circumstances that we have not conceived of.
Yes.
Where damages could arise in a tort like this.
So I would suggest that the court tread very carefully when it comes to the marshal because there is such a widespread statutory regime. If we're talking generally about judgment creditors, if during the course of any judgment enforcement, rights beyond those rights that a judgment creditor would have get violated, and the judgment debtor can show something other than, well, this money that I owed pursuant to a judgment, that's not the damage. But if they say, and in addition to that, I lost X, Y, and Z.
I don't think courts have to answer these questions if they aren't necessarily in front of. We just have to make sure that we don't answer this one in such a way that it precludes the possibility of the next one.
I suppose, Your Honor, that if, careful jurisprudence would warrant the court suggesting that this case may not be all-inclusive, but I certainly would be careful about language that might encourage others to try the same thing. You know, I think that the case you're looking for simply has to wind its way up on those facts. And I agree with Your Honor, it is conceivable, but this case is not the poster child for making a change in law.
I see.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Thank you. First, real quick, on the issue of damages, there's clear damages on the poundage fees. The marshal charged poundage fees in addition. So at a minimum, there are damages there for the poundage fees. And he charged poundage fees by exceeding his authority, by levying outside of his jurisdiction. So you
I'm sorry,
absolutely,
weren't the poundage fees payable by the judgment creditor?
no, they were taken out of the account. We were responsible for those
In
damages.
excess of the judgment amount?
Yes, absolutely. So at a minimum, there are damages at a minimum for the poundage fees. We had to pay for those. So
I'm a little confused. I'm sorry. I've got to follow up on the poundage. I'm on the screen. I thought, at least in one of the cases, there's actual satisfaction of the debt. So you're not being charged for the poundage fees, or did I misunderstand the record?
the poundage fees are added to the levy, yes. If you look at the levy that's in the record, it actually has the poundage fees that are charged, and they're deducted from the account. So those poundage fees are absolutely damages. At a minimum, those are damages that have to be addressed by this court. But think of the rule that this court would send as a matter of public policy. You heard it right here. Whoever gets there first. Whoever gets there first. That's the rule they want you to create, whether lawfully or unlawfully. Reward whoever
But why couldn't the
gets
rule
there
we create
first.
be, stop them from getting there first, so going in Article 52, which is your exclusive remedy here? Why isn't that a bad rule? And then we don't need to answer the first question.
Well, because Article 52 is not exclusive. It's been the common law.
But it's not exclusive, maybe an open question right now, but it could be, depending on the answer we give to question 2. So why would that be a bad rule?
Because it would require multiple steps, Your Honor. For example, just look at what happened in Silvercup.
But you were in there, you were in court, you took this step to challenge the judgment at a time when this was, as I understand it, being executed, and you had notice of that. So what is the extra step? This is an extra step. To bring a federal case against all these people and wind up here is a lot of extra steps. What is the policy reason that we wouldn't want judgment debtors with a valid judgment to go in under Article 52 rather than do this?
Because it's first of all, Article 52 did not abrogate the common law of
No,
wrongful
but
execution.
that's not my question.
And-
We'll decide that,
Sure.
but what is the policy reason for not doing that?
Because a judgment debtor should be able to go into the court of its choosing and pick its
Not
form.
if there's a judgment against it in a court in New York. I mean, that's kind of been answered already, and you have a valid judgment here. So I'm still trying hard to understand why, as a policy matter, we would want this, when if Article 52 is exclusive, and you had notice here, and you could have gone in, you would have avoided this if you were right.
Why would my client, let's say he's in California or Texas or wherever, and if they committed a tort in New York, it's wrongful execution, and they caused their damages, why should I have to come to New York to travel and file
Because
an
you've
action?
conceded to jurisdiction in New York by your confession of judgment, and you have a valid judgment here. It's not like they're hauling you in here, and you said something before, they woke up one morning and the money was gone. Not really. I mean, they had notice it was attached.
I understand, well, actually, the confessions of judgment don't give you notice. They file, this is how it happened, or at least this is how it did happen in the past, is they would file a confession of judgment, and within minutes, they would give it to the marshal, and your bank account would be frozen. So you would have
But you have
absolutely no notice
noticed that the bank
whatsoever.
account is frozen. You had it here. And you had the opportunity to go in, and in fact, went in, you just challenged the judgment, not the execution. So why wouldn't a good rule be, if you're going to do that, and you're coming into New York anyway to do that, why wouldn't the rule be that the exclusive remedy here, rather than try to prove a 140-year-old possible tort, is to go in there and say, the attachment's not valid. And then that court can order it released. No poundage fees, no payroll issues.
It's because if I'm in California, I can do it in California. It's more convenient for me. If my rights have been violated in California, and you've got to remember that these are predatory loans, high-interest loans.
But this rule is for everyone.
May I try a little different version of Judge Garcia's question that is actually, the Second Circuit hasn't asked whether you can't bring a tort action. They've asked whether you have to go under 5240 first, right? So why, I think that makes Judge Garcia's position a little stronger if you think of it that way. That is, suppose you do have a tort action, but the rule is going to be the first thing you have to do is try under 5240. Failing that, we'll leave it for another day whether you can proceed under tort. Well, why is that a bad policy?
Okay. Well, first of all, Article 52 would have to apply, and it would only apply if there was jurisdiction to issue the levy in the first place. So in the circumstance where
You would wouldn't you go in on 52 and say there's no jurisdiction to issue the levy, vacate it?
you could, but the marshal, you don't have to if it's void. It's as though it never happened. If the marshal exceeds his authority.
No, but counsel, I'm sorry to interrupt you. If I'm understanding this line of questioning, the point is you have to go into a court to get a judge to say that.
Correct.
And the question is, why not use what is already available to you? Judge Garcia is saying, you already went part of the way, used part of Article 52. Why not go all the way? And Judge Wilson is saying, well, there's a question as to why not start there, and if there's a deficiency in that process, perhaps you got a tort action. And may I just mention, you keep talking about California. In this case, you actually did come to New York. I mean, you're in the District Court of New York, so I'm not really sure I'm understanding fully that argument.
Well, let me just.
I mean, some judges got to decide what you claim you want decided, that it's void versus voidable, right? Some judge, some court has got to make that decision. So you're going to have to subject yourself to the jurisdiction of the court for that.
Correct. And under the law, we're entitled to choose that forum, whether it's California, whether it's the Southern District of New York, whether we want to go to Broome County or Orange County or wherever. We have that option. We shouldn't be forced into going to a court that is chosen by the happenstance of the judgment creditor. And that's what's happened here, is we have the opportunity. For example, in Silver Cup, it's in Ontario. My client is in New Jersey. Why would I have to go all the way up into Ontario County to litigate it when my client is in New Jersey? It would be much more convenient to litigate this in the Southern District of New York or to litigate it in New Jersey. But because of the way these jurisdictional disputes, they can be in anywhere, any county in New York, and it's picked by the judgment creditor. And so we should have the opportunity to say, listen, I don't want to have to go all the way up to Erie County to fight this. I don't want to have to go to Broome County. I can pick my battle in the Southern District of New York. That
Counsel,
option is always available.
is there anything in the certified question or in the argument that you're making that limits this tort to foreign judgment debtors only? And the question I'm asking is, what's to stop a domestic judgment debtor from bringing the same tort action for wrongful enforcement of the judgment? I know your client has a particular hardship, but is there anything about this that limits it just to foreign judgments?
No, it could be a domestic one too. If, for example, the city marshal were to execute on a bank account or issue a levy in Erie County, then they would be able to bring the same thing.
So any judgment debtor who's unhappy with the way the judgment was enforced conceivably has the right to bring this action for improper enforcement?
Yes, if they broke the law. Think of the rule that if your honors answer no to this question, either one of these questions, Marshal Beagle and all the other New York City marshals can go out there and issue levies anywhere in the country without consequence. without consequence. Why wouldn't they do that? They can get their poundage fees, they can just issue their levies, and
Well,
it's
no, no,
known
counsel,
and willful.
no, counsel, there are consequences. It's just you want a particular judicial forum.
Well,
The question is, which is the proper forum, whether or not there's a particular kind of cause of action. It's not that there are no consequences potentially. That I don't think is a fair framing of the issue. But let me ask you something else. I know your time is short. Should we make a distinction? I know this is in the Second Circuit mentioned it in passing. It's a little bit in the briefing, at least from the amicus. Should we be making a distinction between let's call it for the moment, wrongful conduct to enforce a debt versus wrongful conduct to enforce a valid judgment? Is that perhaps a better framing of the question as posed?
Well, I'll say in the case of the marshal, where you knowingly and willfully execute and exceed your authority, that's a distinction versus, and that's why the sheriff is not in here. The sheriff is not in this case because he served it within his authority. Now, what's the liability on that? It's under CPLR 318. The creditor had the obligation to show to properly serve that levy. There's only two ways you can serve a levy under the CPLR. You have to serve it on an officer of the company, or you have to do it under a designated agent under 318. Now, Comerica doesn't have a principal place of business in New York. Their principal place of business is in Texas, so they don't have a designated agent under 318. It wasn't served on an officer of the company because they're not here, and therefore this isn't a technical defect. It's a fatal defect because they couldn't possibly serve Comerica with a levy in New York because they have no designated agent under 318. They have no officers in here. So it couldn't be done whatsoever. So that's why it's up to that's why the creditor, the CMS, the MCA that directed.
And let me just ask you, given the way you've set out the wrongful conduct, does Article 52 not provide? I understand your point that it's about choice, that you should be able to choose how you wish to proceed given the wrongful conduct. But just to be clear, you're not taking in the position that Article 52 doesn't provide a remedy for the wrongful conduct as you have described it. Is that correct?
Well, all I can say is what happened in Silvercup. So Article 52 can modify a judgment, but modify a levy. It can do that. It can order restitution, which they did. But you have to bring a plenary action. So Article 52 in and of itself is not enough. You can't seek attorney's fees for the damages. You can't seek consequential damages under Article 52. You need an underlying tort action, which is the wrongful execution. So Article 52 in and of itself doesn't do it alone. So you need to go back to the common law and rest on the common law remedies, which are not needed by a plenary action. And in Silvercup, that's exactly what he said.
You mean if the execution, the wrongful execution has occurred, as opposed to if you're able to preempt the wrongful execution?
Correct.
Correct?
Correct.
So you're talking about that smaller class of wrongful conduct.
Correct. And here, I can't say enough that the damages here are clear. There was, let's just use round numbers, $300,000 in the bank account, and then there's then there's not. It's zero. Those are the damages. Now, if they want to say, well, there aren't really cognizable damages because there was a valid judgment, and we're going to use that to collect that's where you have to get into the offset and equities, and that's where you don't get to apply that. A wrongdoer, someone who breaks the law, cannot break into someone's house, take that and say, hey, well, that was mine anyway, now I get to keep it. No, it has to go back. You have to go back and obtain those lawfully. So if that money went back, then it would be back in the bank account, and then they would have to use lawful means to obtain it. And then when they use the lawful means to obtain it, then there was all sorts of the protections that they could go. They could have the receivership could have stepped in Michigan. There are all sorts of protections that were evaded. And I know I'm running out of time, and I thank you so much for your patience. This is an incredibly important issue. But the law of the state cannot be that you can break the law, collect upon a judgment, and then just say, it doesn't matter because there was a lawful judgment. That
Thank you,
can't be the
counsel.
law.
Thank you.
Thank you.
We'll take a break now to execute our cleaning protocol.
You need a yellow pad in it?
No, I have two.
Good afternoon, everyone. I'm Judge Eugene Fahey. Judges DiFiore and Rivera are recused in this action. Counselor, do you want to reserve some time?
Yes, Your Honor. On our
3 minutes?
main argument, 7 minutes, 3 minutes for rebuttal.
Whenever you're ready.
Thank you, Your Honor. Good afternoon. May it please the court and counsel. My name is Deborah Scalise, along with my colleague Annette Hassapidis. We're here on behalf of Larry Halleck and Mary Malober. This case is about issues of fundamental fairness and due process. Every party in every case in every court of the United States is entitled in our system of jurisprudence to know what the allegations are against them.
Counsel,
Yes.
here, sorry, it's a little hard to mask, but I understand your argument. Let's assume, and I know you dispute this, but let's just assume for my hypothetical that there was, that a finding of dishonesty was supported in the record. But same charges, same violations that were admitted to. But the finding of dishonesty is clearly supported by the record. In your view, would that be a due process violation?
Yes.
Why?
The reason being that there was never a dishonesty finding.
No, but let's assume.
Oh, you're assuming, okay.
Yeah.
So, okay. Judge Castell, in this record,
No, but let's assume there was a dishonesty finding. Would it be a due process violation?
well, the problem we have here, and let me just add, if you don't mind, to your hypothetical. We started in one court, we then went to the Southern District grievances, okay? And they rely, our court, the appellate division, relied on what happened in the Southern District
I
grievances.
understand. I guess I'm not articulating this well, but I think what I'm trying to get at is, assume there was a basis for finding dishonest conduct here, and I know you dispute that, but just assume in my hypothetical there was. It seems to me your argument would be the same because you would be arguing, but you weren't charged with dishonest conduct. That seems to be the basis of your argument.
Yes, you do need notice and the opportunity to be
But why
heard.
wouldn't that just fall within 8.4, conduct unbecoming, for want of a better phrase
Okay,
here?
so conduct that adversely reflects on the fitness to
Doesn't
practice.
dishonesty adversely reflect on you?
Well, under 8.4, if you were to take a look at Smolaire's decision, he was actually charged with 3 violations in addition to 8.4H, A, B, and
Yeah.
C. A and B are dishonesty charges, and they have to have intent, okay? C is an administration of justice charge. The only way our court could get to dishonesty on the part of these lawyers was if they had been charged with that. They were not in the
No,
instrument.
but let's just say there was a finding in there. For some reason, they admitted 4, but there's a sufficient basis to find dishonesty. What I'm getting at is, it seems to me the problem here isn't so much you were found to have violated a rule that wasn't charged. It seems to me the problem is, in this view of your view of it, there's a finding underlying a penalty that isn't supported by the record.
That's part of it, but the real issue is you had two separate proceedings with two separate respondents. You had Mr. Smoliar, who had a confidential collateral proceeding where he had the opportunity to present mitigation and testified. You later have this proceeding on a reciprocal discipline with our clients who apply pursuant to the reciprocal discipline rule based on the Southern District of New York's findings. The Southern District of New York's findings, and I'm sure, Judge, that you're familiar with this because you used to appear there, the grievance committee there is made up of judges, okay, who sit and review the record, just like the appellate division does for our grievance committee. The difference being is the judges actually decide, whether to go along with it. So there was a censure for each of our clients, and that censure, if you take a look at it, does not allege any 8.4 violation except for H, which is the adversely
And
reflects.
I understand that. It's just how I'm trying to fit your allegation of what's wrong here, your argument about what's wrong here, within a framework I can kind of understand. Because to me, it seems more as if what you're saying is accurate, if there's no basis for finding of dishonesty, the way the appellate division to me seemed to use that finding was to enhance the penalty. It wasn't to find that you violated another, the case from the Supreme Court where they add a violation later, or, it was used as a penalty enhancer. And to me, if there's an aggravator in the record and they would have said, oh, look at what happened in the Southern District, admitted conduct, even though that doesn't fit neatly within the first three violations, but it doesn't reflect very well on a lawyer appearing in federal court or any court, why couldn't they use that without a due process violation? You've admitted the conduct. The problem here is you're arguing they're using something you have not admitted that isn't in the record, but they were using it to enhance a penalty.
Yes, but even in enhancing a penalty, a respondent should have notice. Any attorney should have notice, or even a judge for that matter, of what they're being charged with. Here, the appellate division relies on Smoliar, who, if you read Judge Castell's opinion, and he was the original fact finder, is repeatedly called a liar, a lone wolf. He's the one who submitted the original affidavit. And there's a footnote by Judge Castell which says there are some differences that are so great, I'll leave it for the grievance authorities.
Did they ever do that, though?
They did not do an investigation. They did not do an investigation. What happened was, pursuant to the rule, and if
That's
you take
okay.
a look at the rule, it just says that the respondent may file an affidavit stating defenses to the imposition of discipline and raising any mitigating factors. They filed their affidavit. They followed the procedure. They did not have a hearing. The appellate division and the grievance committee could have expanded upon that by saying, we want an investigation because there are so many inconsistencies in the record, and we want to know who's being honest.
And they never did that.
They
right?
never did that. The grievance committee did not amend its pleadings. They had a very terse pleading based on the grievance committee for the Southern District, and there's nothing in either of those that mention any dishonesty allegation. The only way you get to the dishonesty allegation is by coupling Smoliar, which is mentioned, okay, with this. Now, if you hold up Smoliar's case and the charges that he was charged with in the Southern District Grievance Committee, you have those violations. My clients do not. Their violations lie in a failure to supervise. That lies in neglect. It does not lie in dishonesty, which is an intentional venal act. An intentional venal act, such as they were alleged to have committed, and there was some incorrect factual basis that the appellate division came to, requires intent and knowledge. Justice Castell said, based on this record, there is insufficient knowledge, and I cannot say that these lawyers acted dishonestly, okay, or intentionally, but I'm going to sanction the law firm. You then take that record, and you could take a look at the pages of the record in his proceedings, He lays out all of the different things that Mr. Smoliar misrepresented to the court repeatedly.
Ms.
And
Scalise,
somehow,
I just want to interrupt before you sit. I have a little bit of a concern with the conclusion that the only place these findings can come from is the Smoliar mitigation hearing, simply because just analyzing the text of the appellate division's findings, I noticed that it tracks almost word for word language that appears in the grievance committee's decision in order. So it makes me wonder whether, in fact, the appellate division is getting this from Smoliar, as you claim, or they're just parroting language from the grievance order.
so they specifically reference the language. If you would hold up Smoliar's decision and the language from the grievance committee in the Southern District on Smoliar, and you hold up the decisions from Mr. Halleck and Ms. Malerba, there's no mention of the charges of 8.4A, B, and C. There's no mirror image of that. The charges that were alleged and the censure that was found is based on 8.4H, as well as the failure to supervise rules.
But I think
Under a failure to supervise.
I think Judge Canataro is asking something a little bit different, or maybe not, but let me try and ask it this way. Can you point to any fact that is in the decision of the appellate division that is not in, that must have come from Smoliar? Any
Yes.
fact?
Yes. So with respect to Ms. Malerba, and give me just a moment to find my page. Okay. There's nothing in Judge Castell's order or in the Southern District order that implicates her involvement in the attorney's affidavit. Okay, so you have three different affidavits. You have the Lucier affidavit, you have the attorney's affidavit, and then you have a subsequent affidavit, which Mr. Smoliar retracts some of his first things, and then another affidavit where he retracts that. And the last two affidavits by Mr. Smoliar were with the benefit of counsel. So basically, Ms. Malerba was not asked by the court to address the attorney's affidavit because it was Mr. Halleck who prepared that, suggested to Mr. Smoliar, this is what you could possibly say, and then Mr. Smoliar signed it. He was the only one who knew the actual facts of what had happened in that affidavit. There is inconsistencies in the emails, and I think Judge Castell, drops a footnote. Mr. Halleck's emails are dated the 22nd, and Mr. Smoliar's are dated the 25th, so someone altered an email. So there is an inconsistency there, but more importantly, in the decision by the appellate division, they say that Ms. Malerba participated in the creation of that affidavit, and she did not.
But here's the thing, and I think Judge Wilson understands the nature of my question. If you go to the very first page of the grievance committee decision, it uses those exact same words. And I'm talking about the Malerba decision, not Smoliar. That Malerba assisted in the submission of a sham affidavit on behalf of her client, failed to supervise an attorney who drafted it, and then assisted in submitting to the courts a letter that contained false statements. Now, I realize that that is not a factual finding. I realize that that's a recitation of an order to show cause.
That's correct.
However, it just strikes me as interesting that the language tracks practically word for word from this language in the grievance committee's decision to the findings of the appellate division. And it makes me wonder whether it is indeed the case, as you say, the only place this could have come from, the appellate division, is the Smoliar hearing.
Yes. So what under Malerba's decision, if you take a look at the language at page 8 of the opinion, okay, it says, based on the foregoing, we find that imposition of reciprocal discipline is warranted. Not only did respondent assist in the submission of the Lucero affidavit, but she subsequently assisted in the submission of the second filing to cover up the fraudulent filing, although less culpable and so on. Here's the bottom line. She did not assist in that filing. That was Mr. Halleck suggesting to Mr. Smoliar, and Mr. Halleck filed that. Thereafter, she was asked by the court to explain the inconsistencies when Mr. Smoliar retracted things, and that's where she gets involved. So they make a mistake of fact and she gets a 6-month suspension based on that. And by the way, if you read through Judge Castell's opinion, the Southern District Grievance Committee opinion, our clients consistently maintained that they knew nothing about Smolier's initial Lucier affidavit. He then admitted on cross-examination by the Grievance Committee that no one told him to do it that way. He decided to do it that way, a unilateral decision. How can they be possibly sanctioned for doing something dishonest that they did not know about? He's the one who's called the liar. He's the lone wolf actor. He's repeatedly, if you look at Judge Castell's decision, it's replete with all the things he did wrong. He's got a 54H violation. He's got a Rule 11 violation.
Let me ask you this, because your time's almost up.
Yes.
If we did remit, it seems to me that the remedy you're asking for is not a remittal, but an actual change of the finding. Is that correct?
Yes, we would ask that you dismiss the dishonesty charges. And that under the case of Dondi, which is a 1984 case, which is the last time that this court had a due process violation, and it's analogous because of the number of years that this has gone on. We'd also state that it would be equitable under the circumstances to dismiss the charge of dishonesty. Ms. Malerba is back to practice. That's not the issue. Mr. Halleck is still suspended. He's awaiting a hearing at the Grievance Committee for his reinstatement. He had a 1-year suspension. It is unopposed, and he still is not reinstated.
Can I just ask you, Ms. Scalise, how do
Yes.
you're asking us to find a due process violation.
Yes.
But how do we do that without explicit references to facts outside the record? Explicitly.
Unfortunately, you can't answer something that you don't know about. So if you're not charged with something, and we have a whole section of our brief of all the things that would have been questioned, but you don't even have to go that far. You can go into Judge Castell's opinion. He's the original fact finder. He was there. He saw what happened. And he tells you all of the inconsistencies. And he tells the court, I'm not going to resolve some of these, and I can't because my record is insufficient. But it's there for the future grievance investigation. And Judge Castell, by the way, was a member of the disciplinary committee in the first department before he became a judge, and then he was the head of the grievance committee in the Southern District. So he's very familiar with how these things work. And I think that that footnote is very important for you to understand because he's saying, there's so many inconsistencies that I can't resolve, and I am just going to sanction the law firm because I don't know that they have knowledge. It's insufficient. So he's saying, you need more to look at this. There's too many things that I can't figure out. And yet, the committee did not do that, and the court did not do that. The committee can regularly supplement charges. They don't have to just go on the reciprocal discipline. If you take a look at the record that is here, they said, based on what is before the grievance committee for the Southern District, they should be reciprocally disciplined. They did not add anything about dishonesty. They said, based on the underlying record from the Southern District, there was nothing that says, we think you were dishonest and answer for it. It would be a simple thing to amend. And if the court felt that there was some inconsistency, instead of using the Smoliar decision, which is a separate disciplinary proceeding that is confidential, they could have sua sponte, held on to Smoliar because cases were pending at the same time, and decided who was telling the truth. Okay, they could have shot it back, and I've seen this happen in other cases, where they could say, we don't think so.
But I thought the
Amend your
Smoliar,
pleadings.
I'm sorry, I thought the Smoliar Appellate Division decision came out, I think, before the orders to show
That's
cause in the
correct.
Southern District Grievance. So don't you think the Appellate Division has an obligation to protect the consumer, the public in New York, that they're going to wait for the Grievance Committee in the Southern District to do that?
Well, that may be correct, but that's not what happened. They could have sua sponte opened a proceeding based on Smoliar. They waited for
Yeah,
the
but I
Southern...
thought you just said, like, they should have waited on Smoliar.
Well, once Smoliar's opinion is, there, okay? What they did when they created the Smoliar opinion were a lot of conclusions about what our clients did, and they weren't there to defend them or explain them, right? I don't know that there's any case law anywhere else where you can have a decision in one case where the people were not given notice or opportunity to be heard or to cross-examine or credibility examined, and make that like a collateral estoppel in the second case, and find that these people did more than that actually was found in 2 federal proceedings. And that's where the due process violation lies, because they never got to say, we don't agree. The Smoliar decision comes to conclusions about our clients that were not even in the record. They just assumed that Ms. Malerba participated in things. And because I think you said it best, Judge, you said, didn't they want to do this for sanction? But that's not enough. If you're going to sanction an attorney and you're going to take their license and their livelihood away, and by the way, an attorney's word is their bond. You say that an attorney is dishonest, it's out there in the public forever. This is something that is really important for you to understand. There's a scarlet letter on my clients branding them that they're dishonest, and they never got the time to dispute that. That is inherently unfair. That is a violation of due process, and we ask respectfully that you dismiss the dishonesty charge, that you remand it back to the appellate division, and that you allow Mr. Halleck to get reinstated immediately based on the Dondi case because of what happened being so inherently unfair and a due process issue. And you may be concerned, what about what happens after this? It is so rare to have a due process violation like this. The last time it happened was 1984.
Okay.
It's 2021.
We have it. Thank you.
Thank you very much.
Thank you for your argument. Counsel, whenever you're ready.
Good afternoon. May it please the court. My name is Rona Kugler, and I represent the New York State Grievance Committee for the 10th Judicial District. The appellate division here properly imposed reciprocal discipline. There was no due process violation here, Your Honor, and there was no finding or charge of dishonesty.
But there was a finding of dishonesty as to Malerba. I mean, it says it in the opinion. It says, we find the respondent's dishonest conduct merits suspension. Well, how is that not a finding of dishonesty?
Your Honor, I'm going to direct the court right now to Rule 5.1 D2 subsection 2.
Yeah, it's a vicarious liability, but this implies direct dishonesty. It doesn't seem to say you are third-party liability for the dishonesty of someone else. This says her dishonesty. I think you can argue that the Halleck one says that because they phrased it differently, dishonest conduct by an attorney. But when you read the two side by side, and you clearly see with Malerba, they're saying she engaged in dishonest conduct, and that was not as bad as what Halleck did. I think the inference is pretty strong that you found that he engaged in, the appellate division found he engaged in dishonest conduct also. So where is the finding of dishonest conduct by Malerba supported in the record?
Your Honor, I'm going to direct you to, I know you're saying not to address the vicarious liability, but I say that that's exactly what we have.
Do you think when I say somebody is dishonest, has engaged in dishonest conduct, that seems to me strongly, and this is attorney discipline. I mean, it is true. This is out there. This is the record of this attorney. This is their disciplinary record. When you say you've engaged in dishonest conduct, shouldn't you then really be careful to be saying you are responsible for the dishonest conduct of someone else because of the rule? I mean, that seems to me a very different conclusion.
Well, Your Honor, two things. First of all, Ms. Malerba did admit to violating the rules, all 4 of these charges, 5.1, B, and D, and 8.4. But, even beyond that, I know what you're saying, but the statute and the court precedent, for example, I'm going to direct the court to a matter of Schwartz. The court said that they are personally liable as though they had engaged in this conduct of the attorney that they were supervising.
Well, I thought the appellate division asserted that Malerba subsequently assisted in the submission of a second filing to cover up the fraudulent filing. All right. Are you saying that that is factually correct?
What I'm saying, Your Honor, is...
Well, I'd like you to answer my question. Is that factually correct, did she assist in the submission of a second filing to cover up a fraudulent filing?
I would say the record supports that, Your Honor. And I would say it because when we looked at the facts of what happened when the second filing was made to the court, at that point, Judge Castell told Mr. Halleck that he needed to submit an affidavit regarding what had happened, and that what happened is he said in his declarations to the court that he at that point reached out and consulted with Ms. Malerba in relation to what had happened there.
All right, let me ask another question then. I understand your answer is yes. You're saying the record supports that.
Yes.
The second question is the Smolier attorney affidavit. Did Malerba have any involvement in the submission or the preparation of that affidavit?
As far as this record goes, there's no indication of what involvement she had. Obviously, she's very different than Mr. Halleck's involvement having drafted.
I just want you to answer my question. Did she have, do you think the record shows that? And where should I look to say that she had some involvement in the preparation or submission of Malerba's attorney affidavit?
Her involvement, Your Honor, was the fact that she knew at that time what was going on, that she had an obligation by these rules to try to mitigate any problems at that point. That would be involved in contacting Mr. Smolier and consulting with Mr. Halleck before an affidavit that was fraught with inaccuracies was submitted to the court.
Ms. Kluger, though, doesn't the district court, they find that there was no venal intent here? So how does the record then become so expansive to include that dishonest conduct, if not for the Smolier separate hearing? Like, how does that expansion of the record happen?
Your Honor, I submit that the record was not expanded here at all. What happened is you have a situation where the rules that they admitted to and that they were found having violated show that you don't have to have knowledge, no actual knowledge needed, no intent, Your Honor. They have the same intent, the same responsibility as the attorney that they are supervising.
But counsel, that's the essence of vicarious liability, and I don't know, it gets us right back to where Judge Garcia was. You have to take this language out of the appellate division findings and imbue it with meaning far beyond everyday vocabulary and usage to see vicarious liability. I mean, the statement is, we find that respondent Malerba's dishonest conduct merits suspension. I mean, that doesn't sound like the language of vicarious responsibility for another person's actions, does it?
When you read what happened in connection with the rules, yes, it does, Your Honor.
So can I ask you a couple of procedural things? On a reciprocal discipline proceeding, can you expand the record without notice?
No, Your Honor. The record is what we had at the foreign jurisdiction.
I'm not asking what you did. Can you do that? Or would you agree that if you were going to expand the record, you have to provide notice? Or at least start a whole new proceeding and not treat it as reciprocal discipline?
Yes, if you were going to expand the record, you would need to provide notice. That's correct, Your Honor.
Okay, and if you were going to sort of evaluate additional charges that the original jurisdiction hadn't considered, you would have to provide notice or start a different proceeding?
Yes, exactly. That is the essence of due process. They would need notice.
Okay, and what about if you were going to just enhance a penalty for something? Would you need notice there or no, in your view?
No, Your Honor, because what happens here is the appellate division has the authority to exercise its discretion in determining what a proper sanction is.
And
Your
it's
Honor,
not bound by the federal court's determination of what, on the same record? I
no,
assume.
it is absolutely not. It is required or authorized to not only give a sanction that is consistent with its precedent, but I'm also going to say that the appellate court here, New York State, where the appellants live and practice law, have a greater interest in the sanctions than the foreign jurisdiction, because this is where they practice, this is where their lives are. And here, in the other jurisdiction, I want to point out, Your Honor, that the stakes were different, because Ms. Malerba was not admitted in the Southern District in the federal court, and Mr. Halleck, who was admitted, was permitted to voluntarily resign simultaneously with the imposition of censure there.
And was the was the legal standard for the sanctions imposed by the federal court under Rule 11 and the inherent power of the court and section, if I remember it right, 1837 maybe? It was, that is, they're operating under a different set of standards. Is that legal standards? Is that fair?
Yes, Your Honor.
Counsel, what's our standard of review of the penalty?
Oh, well, Your Honor, this court should not be, precedent says, should not be substituting its judgment for the appellate division as long as the appellate division did not exercise proper discretion.
So it's an abuse of discretion standard.
Yes, Your Honor.
So what I was asking your opponents here, if there's some finding supporting the penalty, is that an abuse, that isn't supported by the record, is that an abuse of discretion? I'm just asking you as a general matter, not in this case, not the specific finding here. But if there is a finding used by the court to support a penalty, would that be an abuse, and it's not supported by the record, would that be an abuse of discretion?
If there's a finding that was not supported by the record, yes, Your Honor, because then the court would have gone beyond. Yes, Your Honor. Okay. But of course, Your Honor, that's not what
I know you
happened here.
dispute that.
Okay. All right. In addition,
No,
do you
you
have a
go
question,
ahead.
Your Honor?
No, I'm fine, you go ahead.
Okay. In addition, I just want to point out that the sanctions imposed here were consistent with New York State precedent. I'm sure you've seen in my cases, in my brief, there were a number of cases here where similar conduct garnered the same sanction, 6-month and 1-year suspensions, for conduct where someone had forged documents, falsely swore or signatures as genuine and submitted them to the court. I have several cases such as matter of Glotzer.
But those cases are for knowing and intentional misconduct, correct?
Your Honor, if I recall correctly, I believe that at least one of them was the supervision of one of their attorneys. So it wasn't just their own conduct, it was the respondent in the matter. I'm not sure which case it is right now, but not all of them. Your
Somewhat
Honor.
related to that last question, it seems as if in general, and maybe you can educate me about the exceptions, that the suspension remedy seems to apply when there are multiple instances of this kind of misbehavior, whereas censure seems to be the more normal penalty for one-off conduct. And this is, as far as we know, a situation involving one-off conduct. So does that, does that seem, would that rise to the level of abuse of discretion?
Well, Your Honor, this may have been one case, but there were 2 situations here of what had happened. There was the initial false filing of the affidavit of the client, and then there was a subsequent cover-up. So I want to say that was actually 2 situations where false information was submitted to the court. In addition, it would not be abuse of discretion because it is in the general range. Each of these cases are very fact-specific when we look at the decisions of the other matters. And the facts here would support that. It would not be an abuse of discretion. It's in the reasonable names set of range of sanctions that the court has given. We're
Okay.
not talking about like a 7-year suspension or a disbarment. They're very close, and it's very consistent.
Thank you, Counselor.
Oh, thank you, Your Honor.
All right, got 3 minutes, ma'am.
Thank you, Your Honor. There was a question posed, and I apologize because of the mask, I don't know who posed it.
It's okay.
But one of the issue was, based on these facts, can you reach this? Based on these facts, you cannot reach this because there was not a dishonesty finding by Judge Castell or by the Southern District. The only way you can reach this is if you rely on what Mr. Smoliar did, and Judge Castell's record is replete with all of the inconsistencies and what he says, and most of his record is dedicated to all the things that Smoliar did wrong. The only way that our appellate division could have gotten to the conclusions about our clients was to do what they did, was relying on the facts of the Smoliar case.
You're lumping that a lot together because the Southern District, Judge Castell went beyond the lone wolf. In fact, he says you're not being sanctioned as a law firm, which is what he could do. because you have a lone wolf, it's because you've done these other things. Now, I take your point that doesn't rise to dishonesty, but it wasn't that you had a lone wolf employee. I mean, some of the things he found were you could have discovered this conduct, again, all part of the charges that were levied, but that you admitted to. But, you know, look, you found one, and that was just because of this. You didn't check with the client once you knew there was a problem. All of those things Judge Castell lays out. So I think it's somewhat inaccurate to say, at least to Halleck, that it was because they had a lone wolf employee. It went beyond that, and I think
And I agree
that
with
underlies the charges here, which are very serious.
And I agree with that, except that that lone wolf was the person who provided information again and again to the court, which it then came out to be untrue, which he then retracted again. Our clients were the ones who figured out that he had done this before and tell the court about this. He then gets credited by the appellate division, and the appellate division in Smoliar's decision takes for granted everything that he says and says things about our clients. There are two separate proceedings. If the appellate division could have done this without Smoliar's findings, and by the way, it was the same panel a year later, they would have done so. The record, what you're talking about, the things that happened, they lie in negligence or neglect. There was no intent to mislead because the reliance was on Smoliar. So when Mr. Halleck spoke to Mr. Smoliar in order to draft an affidavit for him, it was based on information that Mr. Smoliar gave, okay? The information that he, imparts in the record and that the court relies on is inaccurate, and our clients never got a chance to dispute that. The committee...
I take your argument. My
Yes.
only point was, I think there is a difference in the district court opinion between you're liable because you had a lone wolf and what Judge Castell actually
And
based
I
his
ag-
sanction of the firm on, which was conduct beyond that, which I think went to D. Romanet 2, which was you should have known, you had an opportunity to do something at the time, and it was very easy for you to find the other example later, but you should have really done more originally.
But
That's how I take Judge Castell's finding. And again, I take your point that that is not dishonesty, but I think it goes well beyond, I just had a rogue employee who I failed to supervise.
But what the court says at page 68 of Ms. Malerba is this: while the record before the court is not sufficient to support a finding of actual knowledge on the part of Mr. Halleck of the falsity of the attorney's affidavit, and by the way, that's affidavit number 2, the record also does not support a finding there are exceptional circumstances that warrant accepting the law firm for joint responsibility. But joint responsibility for what happened does not mean that they had knowledge that it was false, okay? You are taking a quantum leap. They're relying on an employee who gives them information that is incorrect, okay? That does not mean that Mr. Halleck intentionally tried to mislead the court. Unfortunately, if you take a look at the timeline, things happened in a very short time period, and as they, unfolded, what you hear is first, the false affidavit, the client testifies, I didn't sign this. Mr. Halleck did speak to the client and said, you had your affidavit, and she said, yes, he puts this in the record. He puts it in the record with Judge Castelli, puts it in the record in the Southern District. So, consistently, he's explaining
I'm sorry,
why he did
can we
or
go
did
back
not
to
do
that?
what he...
I'm sorry, that point where he shows it to the client, I
Yes.
thought the point there was she didn't say anything. Not
That's
that
not
she said I
correct.
signed it.
So there were two different things, okay? He was prepping the client for trial, and it's in the record, and he showed it to her, and she didn't deny that it was hers.
She didn't say anything.
Well, she said, okay, and then when she was asked at trial, she's referring to the affidavit that you give for HIPAA forms, and that's what Ms. Malerba explained later, the affidavit they had. And by the way, Judge Castell does not credit Mr. Smoliar's thing that Ms. Malerba told him that there was these affidavits and she had authorization to to sign and notarize things on her behalf. He does not credit that, okay? So what happens is he does this unilaterally, and he admits in his grievance committee cross-examination that no one told him to do it, he just did it, okay? So on cross-examination in his hearing, he admits that. How does that then come to the point where he was told to do that? That's inaccurate. He unilaterally decided to put that in. When you're then Mr. Halleck, and put yourself in his shoes, at the hearing or the trial, she thinks it's one thing, and then it turns out to be another thing. In order for Mr. Halleck to prepare suggested language for Smoliar, he had to talk to Smoliar to figure out what happened. And that's when he learned what had happened. And he consistently explains that, it was a misapprehension on her part because she was thinking about the one affidavit and, for permission for the HIPAAs, and Ms. Malerba explained that as well. And Judge Castell says, Smoliar is experienced. He knew the difference. He didn't have to sign that affidavit. He knew what was wrong. And that's
Okay.
the point.
Your light's on now, so why don't you wrap it up?
Thank you very much.
Take your second and wrap it up.
Okay. So to conclude this, and if you give me just a moment.
Sure.
This matter was unprecedented. The practice of the appellate division should not be condoned or countenanced. Our clients were suspended and served their time and then some. Mr. Halleck is still suspended. The public interest has been served in this case. What is the public interest? They're to know that there was misconduct. What was the misconduct? The failure to supervise someone who did something wrong. And to discover, you're right, Judge Garcia, that he had done it wrong. But that's a should have known, not what they knew. And dishonesty lies in intentional acts, okay? So the remedy is to vacate the determination of dishonesty, to dismiss any further proceedings against Mr. Halleck, and there's no reason to admit, only to the effect that doing so would unnecessarily continue to punish my client for something that he never had the ability to defend, and she never had the ability to defend, based on the record of the fact finder. Even Judge Castell did not find they had knowledge of what happened. Insufficient knowledge. His statement is that he was going to sanction the law firm because the law firm should have known. But these two individual lawyers, there's a quantum leap that they're dishonest based on what Smoliar said and did. That is unacceptable because they had no ability to be in his proceeding. And they had no ability to challenge what happened in his proceeding. Now, that may have resulted, if they had had a dishonesty charge, in inconsistent findings. But what the appellate division could have done then, if they found and they gave our clients a hearing, they could have brought subsequent charges against Mr. Smoliar if they thought that he was dishonest instead of my clients, because you can't lie in a disciplinary committee proceeding, and there's no statute of limitations or latches. But here, they made a determination. They wanted to just stick with the facts that they found in Smoliar. They then used them against our client in a separate proceeding, which was inherently unfair and violated their due process because they had no notice that they did anything dishonest. They had initially allegations of that, but what Judge Castell found and what the Southern District found does not lie in dishonesty. Someone said vicarious liability. There's vicarious liability, but that doesn't mean you knew about it. You might be liable because you were supposed to supervise. It does not mean that there was knowledge, and that's what's really important to understand here. So to not give them their due process and to later wake up one day and there's a decision by the appellate division labeling you as dishonest, giving you your scarlet letter, ruining your reputation is inherently unfair, and therefore we seek the dismissal of the dishonesty charge and the recommendation based on Dondi that Mr. Halleck be reinstated immediately, and I thank you very much for your time and consideration of this case.
Thank you, ma'am.
Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals held in the State of New York may depart hence